SJC-13110, Kellie Pearson v. Thomas M. Hodgson and others.
Okay, we'll start with Attorney Rothman.
Good morning. May it please the court. My name is Ian Rothman, and I represent the Bristol County Sheriff. I will be splitting my time with Jason Frank, who represents the other defendant, Securus Technologies. Whether one agrees or disagrees with its policy judgments, the intent of the legislature here was clear. In 2009, when the legislature passed the special act for the takeover of the 7 sheriff's offices, it reserved certain revenue streams for the sheriffs. And in fact, it instructed those 7 sheriffs to look for ways to maximize revenue going forward. Before I address the specific provisions of the 2009 Act, I think it's important to talk about what revenue exactly we're referring to here. While this case is about inmate telephone, we're not talking about the telephone calling charges themselves. The revenue we're talking about here is paid for by Securus, the telecommunications provider. From 2011 until 2015, Securus paid several things. First, they paid annual support for administrative staffing and a technology grant. They also paid a site commission based on the amount of revenue they received. The contract was amended in 2015, and site commissions were eliminated. At that time, the administrative and technology support were paid for in a single lump sum payment. Since that time, and outside of the time period that's covered by this case, a new contract has been adopted. And under that new contract, there also are no site commissions. There is an annual $100,000 fund that's provided for the purchase of technology, service, and equipment from third parties. And that revenue is forfeited if not used at the end of the contract.
Let's dig in here because you only have a limited amount of time. So under 12A, the 2009 Act does mention inmate telephone, but as it relates to the inmate calling services, there's a number of issues of at least concern. The first one is that the 2009 Act is all about the Commonwealth wanting to exercise greater control over financial dealings with the county. And I'll ask you about the word remain, because it's the plaintiff's view that remain in 12A means that we're just saying what money that already exists is going to remain with the sheriff in this major legislation as it relates to certain counties. And then the other issue is that when you get to 12A and you see the sort of reference to inmate telephones and civil process and some other issues, that pales in comparison to the specificity in which inmate funds are addressed in other statutes. So as a matter of plain language and legislative history, what's your response to that?
Thank you, Your Honor. A few responses. First, the 2009 Special Act was about the compromise that was and the balancing that was agreed to in connection with the takeover of the sheriffs. And so there are provisions that provide for the takeover of certain functions and responsibilities by the Commonwealth, and there are others that specify which ones remain in the sheriff's offices. And so if you look at the particular construction of that special act, for example, Section 3, Section 4, Section 6, all speak to functions and responsibilities that are taken over by the Commonwealth. Section 7, interestingly, speaks to real property and facilities. And with respect to that provision, there are certain things that are taken over and certain things that are retained in the sheriff's office. Same is true for Section 12, which relates to revenue. Interestingly, Section 11 of that special act speaks to funds in existence as of the time of the special act. And so one would expect if the legislature wanted Section 12 reference to inmate telephone calling to refer only to existing funds at that time, they would have put that provision in Section 11, not in Section 12, which speaks to revenue streams. Section 12 speaks to revenue streams more generally, and it speaks to the issue that was raised in connection with the proposal of the 2009 Act by Governor Patrick, and the differences between the 2009 Act and the proposed 2008 Act, which was not enacted. In other words, the 2008 Act would have, if it had been enacted, would have taken over all functions, including all revenue streams for the Commonwealth. At that time, as was described in the special commission report that was created as a result of this, pursuant to Section 22 of the special act, the special commission noted that the differences between the 2009 Act came about as a result of the unique economic circumstances that we were experiencing. In other words, there was a real estate crash. The real estate excise deeds tax was a major contributor to the funding of the 7 sheriff's offices. And as a result of that budgeting shortfall, the proposed act was modified. And in the 2009 Act, which ultimately got approved, there were revenue streams that were retained for the sheriff's offices so that they could meet their fiscal responsibilities and fund their budgets. Section 12, if you look at Section 12A, 12B, 12C, they all speak to revenue streams. They don't speak to one-time pools of money or one-time funds. So if you look, for example, at Section 12B, it talks about annual conferences with the legislature in order to maximize revenue going forward. If you look at Section 12C, it speaks to sheriffs who have developed a revenue source apart from the state treasury and provides authorization and a grant to keep those revenue sources in place.
What about the specificity required of Sousa, though? 12A doesn't mention charges. It doesn't mention a specific amount. And, we have the caution from Sousa versus the sheriff of Bristol concerning expressly authorized by statute. And that's the key, that's the key principle.
Your Honor, this court in Sousa looked specifically to what is the intent of the legislature. Now, I agree with you. There are certain provisions in statute that provide almost a fee schedule for certain fees that can be charged. And we don't have that here. I acknowledge that and I agree with that, but I think that this is different in a couple of important ways. Number one, first of all, Sousa was predated the 2009 Special Act. And so we have to remember that in referring to and reading Sousa. Second of all, Sousa involved fees that were charged to inmates. What we're talking about here is not a fee that's being charged to an inmate. It's a revenue source that's being derived from a third party, namely the telecommunications carrier. And since 2015, the revenue that's being derived.
Counsel, can I interrupt you for a minute? What if in the haircut situation, they contracted those out to somebody else and somebody else collected the money and then paid the sheriff?
Well, a similar situation is similar to commissary, which is in fact covered in part by the 2009 Act. And there also are certain fee schedules that are required for a commissary. Telephone charges are a little bit different. They are subject to regulation by the Department of Telecommunications and Cable. If you were to look at the request for responses, which the sheriff's office released as part of the bidding process to get this contract, there are certain provisions. There are almost 40 pages of technical requirements that the telecommunications company needs to meet in order to get the bid. And among those technical requirements are compliance with the Department of Telecommunications and Cable's rate cap. And there is a sort of a separate regulatory scheme that relates to the cost for interstate and intrastate telephone calls. Now, as I said, I acknowledge there is no fee schedule in the statute or in a statute for telecommunications costs.
And I know you acknowledge that. I appreciate that. So as it relates, again, back to Sousa, you have to go back to the 1997 statute. And this is a sea change as certain county governments are eliminated, but the sheriff's offices remain with robust responsibilities. But there's a lot of gray. And so Sousa makes the point, considering that something for the sheriff to have that responsibility, the language is it has to be expressly authorized by statute. It's sort of an emphasis there because of the duality going on within the county. What's your response to that?
Well, first of all, it is expressly authorized because Section 12A says revenue from inmate telephone. And that's an express authorization.
Well, I mean, it's very specific, though. It says it's the revenue from the telephone services shall remain with the office of the sheriff. And so it's not clear to me, at least, whether those are future revenues or just revenues at the point of the transfer.
And I understand the awkwardness of that language.
Well, especially in light of what you just said earlier, which is that Sousa regarded came before the 2009 Act. So in light of Sousa's admonition that if you want to allow the sheriff's office to charge fees, you have to be very granular. And this being less than granular, I guess I don't know why we would interpret it to allow the sheriff to continue to accumulate these commissions.
Your Honor, Sousa says that the statute needs to be an express expression of intent, but it doesn't say it needs to be granular. And the intent is clear.
Well, don't we divine intent by the plain and ordinary meaning of the words chosen?
We do. And the plain and ordinary meaning of revenue here, if you look at it in all of the ways in which it's used, is a revenue source. It's a stream of income. And that's the way that it is used. And I know my time's expired, but if I could just make one more related point, which is if you look at the special commission report, which was provided in response to Section 22 of the Act, there was a discussion in there specifically about inmate telephone. And it is clear, contemporaneous with the statute, that it was known and understood that revenue was remaining in the sheriff's office. And in fact, there was a recommendation from the state auditor, which is expressed in the special commission report, that says that money should be remitted to the general fund of the Commonwealth. And the recommendation was rejected by the special commission with a 6 votes against, 0 in favor, and 1 abstaining. And that vote is recorded in the special commission report in one of the appendices, which is included in the joint appendix.
Okay, thank you.
Thank you.
Okay, Attorney Frank.
Good morning. May it please the court, Jason Frank from Morgan Lewis on behalf of Securus Technologies. I will be exceedingly brief. In the district court, the plaintiffs made it clear that, quote, the plaintiffs do not challenge Securus's call rates. They stated, we wouldn't be here today if Securus had instead kept all the money for itself, close quote. In other words, one issue that is not before this court is the reasonableness of Securus's call rates and whether Securus was entitled to charge them. This point is particularly important because in the complaint, plaintiffs make reference over and over again to allegedly inflated call rates, and the ACLU and others actually filed an amicus brief in this court which had the sole focus of whether call rates were inflated and the impact of those call rates. But this case isn't about inflated call rates, and it couldn't be. And that's because the sheriff's RFR in this case specifically required any bidder to comply with regulatory limits on call rates, including the Massachusetts DTC's limits. And Securus has done just that. The question for Securus is, can there be 93A liability for allocating some of its revenue to the sheriff to pay for administrative personnel, telecommunications technology, and initially in this putative class period for site commissions? The plaintiffs are asking the court to hold that the way that Securus divvied up its money is contrary to law, even though Securus was allowed to charge what it's charged. Now, the
But
issue.
isn't it true that if Securus didn't have to pay commissions to the sheriff, that the overall rate would be lower? That is, I'm familiar with the proposition that you pass the costs on to the consumer in order that your revenue doesn't take a hit.
Respectfully, Your Honor, no.
No,
It
you've not
is-
heard that proposition, that you
it-
pass the costs on to the consumer.
It is, the fact is that a number of factors go into the setting of rates. Of course, costs go into the setting of
Right, and
rates.
so now one of the costs Securus has is the need to pay the sheriff's office these commissions.
But it does not necessarily follow that rates would be adjusted upon the cost structure changing, Your Honor. And in this case, there's no evidence that when site commissions were removed, that the cost structure did change. What is the fact is that the call rates are not only not challenged by the plaintiffs, but that they are consistent with regulatory limits. And they actually cannot be challenged, and that's why plaintiffs haven't done it. Now, the 93A issue is not before this court. But there's certainly no liability for Securus when it charged the legal rate and then paid amounts to the sheriff that a Massachusetts law expressly states that may remain with the sheriff. And in answer to the last question by Justice Wendland to Mr. Rothman, I'll add that 12A specifically identifies two other revenue streams, and there can be no doubt that it wasn't just referring to revenue that currently existed, but he was clearly referring to revenue going forward with respect to those two. And there's no reason to believe that one should parse out that statute and to suggest that the inmate call funds should be transferred only as of that date, but not going forward.
Just so I can focus though on the issue, there's nothing about the certified question that specifically needs to be resolved as it relates to your client, is there?
That's true, Your Honor. So I will conclude on that point by noting that for all of the reasons that Mr. Rothman has stated in his briefing and argument, the legislature clearly intended for the sheriff to be able to generate revenue through inmate calling services and to retain it. The sheriff was authorized to do what he did, and Securus could incur no liability regardless. Thank you, Your Honor.
So you just wanted a chance to argue before.
But there's no doubt that that's appealing, but
No pun intended.
and we do join the sheriff's argument, and there are good reasons why this court should essentially affirm the district court's order. Thank you.
Thank you. Okay, Attorney Pension.
Good morning. May it please the court. My name is Jim Pashaw, and I represent Kellie Pearson and the other plaintiffs in this matter. In Sousa, this court made it clear that the powers of the sheriff are defined exclusively by the legislature, and under the statutory scheme set forth in Sousa, the sheriff has the burden to show that the legislature has given him the express authority to raise revenue to help him support the required services at the jail. Sheriff Hodgson has not met his burden here, although he concedes that Sousa requires express legislative authority to collect the commissions and other payments. He claims that the 2009 special law gives him that authority. The sheriff's argument.
Let's just put aside for the moment that that we've got 12 Ed mentioning telephone, the issue of telephones, but what do we make of the 2008 proposed legislation that would have all the money, all the revenue go to the general fund? And then a year later, not only did 2008 not pass, but then a year later, we have a different economic landscape, and you have the interpretation of the sheriffs that now, due to the requirement of trying to look for other funds, that they can keep the revenue from an inmate calling service.
Your Honor, the legislative history is very clear that the only debate was whether or not the sheriffs should be able to keep revenue or should they have to return it to the general fund. There was
So then what happens with future funds, when future
so
funds? are collected?
I'm glad you brought that up, Your Honor, because I'd like to correct, I think what's a serious mischaracterization of our position by the sheriff. We do not take the position that 12A refers only to funds that were in the sheriff's possession at the time of the transfer. We acknowledge that 12A contemplates an ongoing stream of revenue, but the question is, what should happen to that stream of revenue? Not is it authorized in the first place? You know, our position is that 12A, when it talks about telephone funds remaining with the sheriff, simply means that the plain language allows the sheriff to keep that money instead of returning it to the Commonwealth, but it doesn't say he's allowed to collect it in the first place. That wasn't an issue that the legislature was deciding or even thinking about when.
Well,
when
counsel, aren't these inmate telephone charges a revenue source?
Absolutely, they're a revenue source, but
And so then under 12C, why is the sheriff not entitled to keep that revenue source?
The 12C, Your Honor, says that the sheriffs can develop new revenue sources, and if they do, they can keep it. But it doesn't give the sheriffs any legal authority to develop revenue sources that haven't been previously authorized. It allows him to do things like expand industry programs, to enter into contracts with ICE, for example, to do other things to expand revenue, but it doesn't say that anything that you can dream up is therefore lawful. Implicit in that 12C is a requirement that you have the legal authority to raise revenue in that way. And in that sense, 12C is no different with respect to the transferred sheriffs than the abolished sheriffs. All sheriffs have the right to raise revenue in new sorts of ways, provided that they have legal authority to raise that revenue in that particular way. What 12C does, which distinguishes it from the abolished sheriffs, is that it says if you can come up with new ways of making money, you can keep that money, as opposed to the abolished sheriffs who would have to give it to the Commonwealth. So it doesn't expand the powers of the sheriffs to do things that would previously have been unlawful. And this is all.
But prior to the 2009 Act, didn't the sheriff have a revenue source that constituted inmate telephone services?
I think that, it's quite clear by the fact that the legislature uses the words telephone funds in 12A that it was aware that there were telephone funds coming in from somewhere. They may not have known how they were coming in. They may have been coming in through Securus. They may have been coming in through fees charged to inmates. They don't specify how they came in.
So with the knowledge that there is a revenue source that constitutes inmate telephone calls, I guess I'm wondering what 12C, what your argument is with regard to 12C, because it seems like the legislature, knowing full well that there is this existing revenue source that constitutes inmate telephones services, then says any sheriff who has developed a revenue source may retain that funding.
So I think that, gets to, really maybe the heart of what this case is all about, which is when the legislature says that a sheriff can keep telephone funds or retain a revenue from some other source, does that mean that it is authorizing and putting a stamp of approval on that source, or does it simply mean that the sheriff can keep it as opposed to sending it back to the state? And that the whole point of this statute was to deal with the transfer and all of the logistics that go along with that transfer. And one thing is very, very clear, and that's in section 15, which is that the legislature did not want to do anything that would expand or reduce the powers of the sheriff. It was dealing with how to effectuate this transfer. It was not saying anything about whether the sheriffs had new power or changed
No, but
powers
it's
to operate the jail.
punctuating the point, though. It's punctuating the point that, and this is forward-looking, that the sheriff maintains administrative and operational control over the office, the House of Correction, and that's forward-looking. And we look at revenue under 12C, and then we look at specific reference to telephone revenue. And I'm having a hard time understanding with that statutory scheme, especially contrasting the 2009 legislation with the 2008 that didn't pass, why where we're asking the sheriffs in this economic landscape back in 2009 to be creative, why they didn't contemplate that those revenues would remain with the sheriff.
I think they did contemplate that revenues would remain in the sheriff, but as opposed to the other sheriffs who had to return it to the Commonwealth. That was the question: who gets to keep the money? Does the sheriff get to keep it, or does it go back to the Commonwealth? But whether the money was collected lawfully or not wasn't. It may have been assumed by the legislature that it was lawfully collected, but even as the sheriff acknowledges in his brief, that assumption may well have been incorrect. And the fact that the legislature may explicitly mention an agency practice and even mention it in a way that suggests that it approves of it does not mean that the legislature has endorsed that practice or even that it has evaluated its legality. And I think the snail darter case, TVA versus Hills, decided by the Supreme Court, is instructive here, because there, after the construction of a dam was stopped by the Endangered Species Act, Congress passed an appropriation act that specifically funded completion of that dam. And the TVA argued, well, Congress wouldn't have funded the dam if the statute had prohibited its construction. And the Supreme Court rejected that argument, saying that even though Congress presumably believed that construction of the dam was lawful, that wasn't enough. That was not enough to establish that it had given it the stamp of approval and that the Endangered Species Act didn't apply. Similarly here, the fact that the legislature may have assumed that the sheriff was entitled to collect telephone revenues doesn't mean it gave him that authority, or that it gave it to him with that act, or believed that he already had it. And this is the policy behind this is that a legislature is entitled to address a specific area. Here, transferring control over to the Commonwealth, without having to worry when it's doing that about inadvertently sort of upending the previously existing statutory framework that governed the powers of the sheriff. And here, it couldn't be clearer that the basic point was that, and it says it pretty explicitly in section 15, we're not changing the powers of the sheriff under the common law or under any of the statutes. He has whatever powers he had before, he has now, no more, no less. So they may have assumed that it was legal, but that doesn't mean that it was. And then when you look at—
So counsel, what is the parallel in this case to the Endangered Species Act in the federal case?
Sousa,
What makes it
basically,
illegal?
Sousa is, it means that you have to apply the Sousa framework, which is, Justice Lowy has said, very clearly requires express authority for a sheriff to demand payments either from prisoners or from family members in this case, or for family members indirectly through Sousa. So you have to look at the broad purpose of this law. First you look at the plain language. Remain doesn't mean collect. Then you look at the broad purpose, which was to deal with what do you do with this money? We know it. We know you've got it. We know it's coming in, and we have to deal with this practical problem. What should happen to it? Should you get to keep it? And the legislative history shows, okay, the sheriff's made a good case that they want to control the money. They don't want to have to give it back to the state because maybe it can supplement their budget, or maybe they have more control over how it's spent. But the question that the legislature faced was simply that: should the sheriffs get to keep it, or should it?
Wouldn't that argument have more heft if we didn't have the legislature including in the statute 12C? Talking about developing a revenue source and retaining funding to address the needs of the citizens within the county?
Well, first of all, Your Honor, that Section C looks forward prospectively, and the legislature certainly isn't saying, okay, you have a carte blanche to develop any source you want, whether it's legal or not. And just on this vein,
It says who has developed, though. I mean, fair
Well,
enough, but it says who has developed.
I think that means going forward, as well as things that have been developed in the past. But as with telephone revenues, they're not saying, okay, we are pronouncing in 12C that all the things that you've done to raise money are now legal. They may be or they may not be, but they're not immune from challenge by virtue of 12C. Like for example, the sheriff mentioned DTC and rates that are consistent with DTC. In fact, the sheriff and Securus withdrew its tariffs from DTC and charges rates that are in excess of what DTC allows. That doesn't mean the 12C now insulates him if somebody wanted to raise that issue down the road, or anything else that the sheriff might do to raise revenue that might be unlawful. He could contract out prisoners to industries in ways that are unlawful, but 12C doesn't put the stamp of approval on that. 12C simply says that if you are able to generate a lawful source of revenue, something that's within your existing authority that we have given you, you can keep it. You don't have to give it back to the state. That's all, and that's all that it does. And I think it's consistent with the whole theme here, which is the legislature was dealing only with the question of who gets to keep the money, not what they weren't trying to expand. And the procurement authority that the sheriff relies on, stems from his general authority to operate the jail. the 2009 Act, it's very clear that the Sheriff's Procurement Authority, the authority to enter into a contract with a company like Securus would not be sufficient to authorize him to make these payments. So he's resting on the notion that because the legislature knew about telephone revenue, talked about it, allowed him to keep it instead of giving it back to the state, meant that it was also allowing him and had given us an endorsement to the legality of his collection of it. And that simply wasn't an issue that was before the legislature. There's no evidence in the legislative history that they ever considered it or thought about it. And if you take it to the logical conclusion, it would mean, well, sheriffs can now demand that prisoners pay a fee every time they want to use the telephone, because that's telephone revenues. It sort of would undermine Sousa. It would undermine all of the principles in Sousa, and that's not what the legislature intended or contemplated.
Okay, thank you so much. We'll take our morning break at this time.
All right.